Okay, let's go on the record on cause number DC 1917340. Fisher v. Fisher. Council, make your appearances.
Go ahead,
Your Honor,
sir.
Seymour Roberts, Larry Friedman, Paige Hawkins, and Amanda Hadrick here for Clifford Fisher and Company and Clifford Fisher.
Mike Lynn is here along with Kyle Gardner for Gail Fisher, who is also present.
Carrie Schoenwald on behalf of Larry Teal and Ted Uzelak.
Okay, so according to the clerk's office, this is what was set for today, and this is what I read, and this is what I'm prepared for. And I'll read out the motion, the name of the motion, since there's seems to be some degree of difference on this. It's the motion in brief for order striking plaintiff's exceptions to auditor's report and the alternative motion for leave to file exceptions and for sanctions. That's all that's set for today. There's some discussion about other things being set. That's all that's set according to the clerk's office.
That's right, Judge. This is a procedural motion to strike a pleading. That's all it is.
And we think it's a good deal more than that because it raises substantive issues. And we will be proffering Mr. Patton on the problems that are associated with the audit.
If the court permits, I'm sure Mr. Lynn can make a bill of exceptions.
Yeah,
I will make a proffer to the court. So this is a record that I want absolutely clear with our expert on the record, because this is a mandamus issue. And I want this transcript to be clean and appropriate for the courts of appeal.
okay, well, we're starting off with the motion to strike. You know, I've actually taken a look at this. I know this has kind of been briefed before. I don't see where I have any discretion to allow a late filed exception. And so I may, you know, if the law was written according to me, this seems like a kind of a harsh remedy, but I looked at this pretty extensively, and I had an intern write an extensive, very well written memo on this. And they also, without me talking to them in advance, also agreed, I don't see where I have discretion. And so before we get to the issue of proffering and all these other things, show me where I have discretion to allow additional time to file an exception. And that's the first issue.
I will, Your Honor, if that is that addressed to me. There's there's something that's shown up on my screen saying the meeting is being live streamed, and then it.
Yeah, you need to click that out. The meeting is being live streamed.
Okay. We don't know how to click. I don't think we control that issue.
You just have to click on it, whoever your tech person is.
Your Honor, if it pleases the court, let me go through this, because I think that this is.
Well, wait a minute.
Wait, Mr. Lynn. The one thing you can go over before we get into anything else is where in the statute do I have discretion to give you additional time to file these exceptions? That's the only thing you're allowed to address at this point. Otherwise, we'll just start with Mr. Roberts.
172 begins with the idea that the audit has to be done for justice.
Share the screen, because I don't see that in the language.
You don't see it in 172?
Yeah, I mean, go ahead and share screen the 172. I don't see that in the language anywhere that there's additional time that I can see additional time.
We can. I'm conflating two different issues. We had your order said that incorporated the fact that we get the work papers. Your own order says I get those work papers if, in fact, I make a request within that 30 days. I made the request within the 30 days. That auditor had 5 days to give them to me, and he didn't do it until May 2nd. So as a result of that, the time does not begin to run until 30 days from May 2nd. That was the order that you committed.
Mr. Lynn, I've asked you a couple times on, can you share screen rule 172, or Mr.
Sure, if we can,
somebody share screen rule 172.
Can you enable screen sharing, Judge Hoffman? This is Kyle Gardner.
Okay, here it is. Got it. We got here.
Okay, that's tiny.
Okay. Can you see it?
Is this the entire rule?
This is the
No.
entire. Right. I have to see 172 in mine. I can't read it. Mike, here. Okay. Your Honor, let me read this aloud since it's so difficult to read. When an investigation of accounts or examination of vouchers appear necessary for the purpose of justice between the parties to any suit. Well, that's the first hurdle. That this 170 audit is not an appropriate audit under the rules. And we can go further into this. It certainly doesn't deal with any kind of justice related to Gail or Cliff. He goes on to talk about the court shall appoint an auditor or auditors to state the accounts between the parties and to make a report thereon to the court as soon as possible. Your order does not do that. Your order talks about asking this person to look at things like the minutes of the board of directors, the contracts, and to make all sorts of merits-based discovery and conclusions. And we have a right to a jury trial and a right to a district judge making decisions on these matters, not an auditor.
Mr. Lynn, the language of this order, and correct me if I'm wrong, Mr. Roberts, was agreed to by both parties.
No, it was
It
not.
absolutely was, Judge.
It was not agreed to by both parties.
It was, Judge. You
No,
asked
it was
us
not.
to submit, Judge, you asked us to submit areas of investigation. We submitted them. I submitted them. Mr. Lynn submitted them. You will see in the amended auditor's report, you will see in the amended auditor's order, a huge chart that was submitted by Mr. Lynn of all the different transactions.
We objected from the very outset.
I'm still
Seymour,
talking.
I get to finish my argument.
Whoa. Let Mr. Seymour finish.
Mr. Lynn submitted a huge chart of all these different transactions that he wanted investigated. They're in the auditor order. You asked us to submit areas of investigation. We both complied. You put them into your order. So we both had the issues that we both wanted. So you're right.
That is completely untrue. That is
Mr. Lynn,
untrue.
you were not an attorney at the time of this order was done. I think that's exactly.
No, I was an attorney at the time this was done, and I specifically objected. And if you go back and look at this, Your Honor, we have objected that this was an inappropriate 172 order from the outset. We, in fact, we went through and critiqued every one of the statements or that are requests that they made and put into this as inappropriate. It is not.
Okay, remind me of the time frame on this.
We did this in January or February.
When was the order? When was the order of the auditor entered?
Somewhere in January or February.
Judge, there are two
February
orders.
28th. February 28th.
There are two auditor orders. The first auditor order was December 23rd of 2021. And as you will recall, you asked us to submit our auditor orders. We submitted one. Mr. Lynn did not. We then had another hearing and we had an amended auditor order entered on January 7th. By that time, Mr. Lynn figured out he hadn't submitted his requested order the first time, so he submitted it for the second order. We each submitted areas of submission. You incorporated them into your order. So we had the original order in December, and we had the amended order in January.
It is utterly untrue. It is completely untrue. If we go back and track this,
guys,
did we agree to this?
So this is the order. You only provided whatever you share screen before. I think only part of Rule 172. This is the entire Rule 172.
Right.
And Rule 172 says exceptions to such reports or of any item thereof must be filed within 30 days of the filing of such report. That wasn't done.
But that report, your order said that I get the work papers as part of that report if I make a request. You engrafted upon that I think the necessary requirement that I get those work papers. That auditor did not give me those work papers within 5 business days after I made the request.
Okay.
Yeah, but the problem is
So
that
if he didn't give me those work papers, the time does not begin to run.
Oh, that's absolutely
It
false.
cannot
under
be
case
that
law.
you order them to do something and
Mr.
give me the
Lynn,
same document.
do you have any cases that indicate that I, as a trial judge, have the ability to extend this 30-day deadline?
You have the ability to change any of the deadlines. The rules themselves say that you have the right to change any of the deadlines in the rules. You have discretion, and when you put an order in there, and I rely upon your decision that I get the work papers,
You requested the work papers 29 days after the report was
right,
done.
but that was following your order. Your order said I had 30 days to do that, so I did it. I went ahead and made that request within that time frame.
Mr.
And
Lynn,
that meant that they had to give me
Mr. Lynn, was there anything in that order that indicated that the deadline for filing exceptions was extended in any way?
It said that I get the work papers as part of your
Mr.
order.
Lynn, you're not answering the question.
No, I am answering the question, Your Honor. I get the work papers as part of the order. You basically said there is no auditor's report unless I get the work papers.
All right, Mr. Lynn, Mr. Roberts, is there anything in the order that indicates that the deadline to file exceptions is extended?
There isn't. Rule 172 applies, Judge. And here's what Mr. Lynn isn't telling you. What Mr. Lynn isn't telling you is that on the day after the auditor filed his report, we sent Mr. Lynn a link to all the documents we gave the auditor. Mr. Lynn waited 28 days after that till the 29th day to ask for the documents, so that the 5-day period the auditor was entitled to rely on gave him until August 4th. So he had until after the 30-day deadline expired to give Mr. Lynn the documents. What Mr. Lynn isn't telling you is, here is all he needed to do. He needed to file an exception that said, I don't have the work papers, I accept. If he had filed that 10-word, 1-sentence exception, he would have preserved Gail Fisher's right.
There is zero law to support what Mr. Roberts has just said. Zero. You have an order that said that
wait, guys, one at a time.
He's making up law. There is no law out there that says that when Your Honor says I get work papers as part of that audit report, that's the point. The time can't begin to run until I get a full report, which includes the work papers. And I requested them, and I didn't get them until about 2 months later on May 2nd, I got them. Within 30 days of that date, I filed these exceptions. So
Judge,
this
is written in
I
English,
permit
Judge,
you to modify every date in the rules.
Okay, Mr. Lynn,
that a
thank you.
second grader could understand. It says exceptions to the report must be filed within 30 days of the filing, not within 30 days of when you get the work papers. It's within 30 days of the filing of the report.
That was modified by the order. The order says I get the work papers, and you cannot look at that auditor's report and make a decision unless you have the work papers to understand the problems associated with that audit.
Well, then you just should have written an objection that said, I don't have the work papers, I accept.
No,
and had you
I don't
done
have
that
to do
bare
that. I was
minimum
following
amount,
the judge's
you
order.
would have preserved your time. But you
I was
didn't
following
do
the
that.
judge's order.
Okay, guys, okay. I've looked at this in great detail because I know this is an important issue. I tend to agree with Mr. Roberts. I don't understand why there weren't any exceptions filed if there really is that big an issue with the order. And so I
Because
don't, wait, don't interrupt me, Mr. Lynn.
Yes, sir.
I don't see how I have any discretion to extend the deadline under the rules. I don't see how this order in any way affected the ability, Mr. Lynn, of you to file exceptions. I'm gonna strike the late filed exceptions. I don't think I have any discretion to allow them. If the rule was written differently and it says should be filed within 30 days or 30 days, but can be extended with good cause, I probably would. I've looked at the law. I don't see how I have discretion. I don't think anything that you said, Mr. Lynn, indicates that the terms of this has been modified. So I'm going to have to unfortunately file I'm going to have to grant the motion to strike.
I would offer Mr. Patton's testimony as a proffer.
I don't think it makes any difference. You can proffer it in an affidavit if you want it. I don't have discretion to do this, to extend the time. I don't see how I have any discretion given the language of the rule. So what Mr. Patton might say about this is, I think, irrelevant because I don't have the ability to extend the time for.
Your Honor, did we offer the affidavit of Mr. Patton as an exhibit to this?
Exhibit will be admitted as exhibit 1.
And Your Honor, I would ask Kyle Gardner to respond on the timing issue.
Judge Hoffman, can I just say one thing very quickly?
I
apologize. Under Rule 5, the very beginning, the preamble of Rule 5 talks about discretion in terms of when by these rules or by a notice given thereunder or by order of a court. So I'm just pointing out that under Rule 5, you have discretion to extend any deadline even under the rules. And that's it. That's all I wanted to add.
I appreciate you saying that. Thank you, Mr. Gardner. All right. What's your next issue, Mr. Roberts?
Well, Judge, we have 2 issues. The issue is striking, and the second issue is our attorney's fees for having to prepare this motion. You know, you entered an order that said that they didn't get that the extension of time was not granted, and despite that, they went ahead and they filed their exceptions, and we filed a motion to strike, and we shouldn't have had to do
Mr. Roberts,
that.
let me ask you a quick question. Did I sign the order saying that they could not have an extension of time? Did I actually sign that?
Yes, you did. And that's our slide 1. If Amanda will put that up.
Amanda, can you put that up?
Put that up. You signed an order on July 16th that denied them the right to extend time under the scheduling order and to
Can I see that, Amanda? I'm sorry, I don't know what Amanda's last name is. So
Mrs. Haydrick. Amanda,
Ms. Haydrick,
can
if
you
you
put that
could
up?
Yeah. I just need permission to share my.
It is, you do have permission.
Oh.
And Judge Hoffman, I'll point out that the date that you signed the order was almost 2 months after we filed the exceptions. So naturally, your signed order was not before us when we filed those exceptions.
But nevertheless, okay.
Well, not that nevertheless, that's the entirety of the point. We did not disobey a court order.
No, there's more. Okay, so you said motion to extend time. You have denied their right to extend time to go against the auditor's report. But the reason why we're filing we think we are given we're entitled to our legal fees is we think there's been an abusive process. We had a hearing months ago on this issue. You said what you said. You said you were going to grant the order. It took a while to file it, but we believe that Gail Fisher has abused the legal process by filing her exceptions, even though she missed the deadline to object.
So can I ask a question just to time-wise? So when were the exceptions filed?
The exceptions were filed on May 31st, and so it was before you signed the order.
So the filing of the exceptions is I'm not going to grant sanctions for it. What I'm more concerned is why we're continuing to fight over this. I mean, you guys have filed additional motions. I've ruled on this. If you feel I'm wrong, mandamus me. Court of Appeals may say I do have discretion, or there should be some other issue. I'm just looking at the plain language of the rule and the case law that I've read. I don't have a
Judge,
strong
may I-
opinion.
Judge, may I submit the proposed order? I'll circulate it to Mr. Lynn and Mr. Gardner and then send it on to you.
Well, I need to know about the sanctions then. What are you still seeking sanctions?
No, Judge, we will not seek our
Okay.
legal fees.
Then good. That I didn't really want to award sanctions. So, all right. Anything else, guys?
The only thing I'll leave you with, Judge Hoffman, is again, in part materia, you read the rules as a whole, and Rule 5 applies to Rule 172. It's a part of the same body of rules, and that's the reason Mr. Roberts extensively briefed the good cause issue, as did we.
Well, but the problem with the good cause issue is that it is good
It's on the
cause
merits.
shown.
It's on the merits. You disagree with our good cause argument. That's fine.
Guys,
but that's a
I've
different issue.
already ruled you guys. If you want to go offline and fight with each other, you can. Did everything work out okay? I know Mr. Friedman and Mr.
Yeah, we
Gardner
did.
were
We
in a
kissed-
deposition yesterday, and there was
No. We kissed and made up. Everything was fine.
okay, good. Everything worked out.
All
All right.
Judge,
Anything
I
else
will
we need to?
circulate the order and then present it to and then upload it to the court.
Mr. Roberts,
No,
let me give you some instructions.
We take that this was the order was in, Your Honor, we
Don't stop
are
it,
going to-
Mr. Lynn. Stop interrupting me, please. Let me
I'm
finish.
sorry,
my
it's hard to
sentence.
see that you're talking on the
Okay.
machine.
Let me just say this real quick. Mr. Roberts, when you submit the order, it's gonna, this is important, so write this down. That it says at the beginning that this was heard on July 29th, 2022. E-file it and email it. And please have your staff, or if you could call Rhonda when you get it, tell her the order is very important and that she needs to put it in my queue.
I will do that, Judge.
Okay, but before you do that, make sure you share it with Mr. Gardner and Mr. Lynn before you submit it to me.
Judge, I love sharing with Mr. Gardner and Mr. Lynn. I'll be glad to do that.
Okay, but make sure you call Rhonda and tell her to put it in my queue. I'd like to get it by sometime early next week. I don't want to get this 3 weeks later or 3 months later. I want to get it next week.
Judge, I'm going to be working on it as soon as this hearing is over.
Mr. Lynn, you wanted to say something else. Go ahead.
No, Your Honor. I mean, we obviously will take this up. So I need to know the timing on the order so that we can make sure we have that, we have our appellate record complete.
I'll try to sign it as quickly as I get it, but the clerk's office doesn't forward. I don't think they forward orders to you. So, but Mr. Seymour, if you could Mr. Roberts, I'm sorry, if you could share with Mr. Lynn when you talk to Rhonda, like don't wait 5 days. Tell her, hey, I just talked to Rhonda. I asked her to put it in the queue, and once it's in the queue, I usually can sign it within 24 hours.
Judge, I'll be glad to do that.
Judge, one last thing. I just wanted clarification on the affidavit that was submitted. Is that part of a bill of exceptions? Because there's not an evidentiary hearing. And if they're submitting an affidavit, then we get a chance to make objections, hearsay, and relevance.
Those were filed with the brief.
It's clearly irrelevant, and there's no authentication. So I would object to the affidavit being admitted as evidence.
Okay, so I'm gonna admit it as a bill of exceptions, and if you want to make any type of objections to it, you can on appeal.
All right, thank you.
Thank you, guys.
Thank you,
You have a
Judge.
great rest of your day, and we will see you soon, okay?
Thank you very
All
much.
right.
Thank you. The interns could wait around.